Hi there, Jim. How are you?
Good. Can you hear me?
Yes, I can. I can now.
Thank you.
Right. Well, welcome. We're going to just wait a couple minutes for some more folks to hop on and we'll get started.
Okay. Thanks, Christine.
You got it. All right, so it is the top of the hour right now. It looks like folks are still trickling in. Luckily, they'll have the opportunity to hop in at any point during the call, which is positive. So I think we'll just go ahead and get started since we want to make sure to honor your time and your time, Jim, and honor your time, Rachel. So for those who are hopping on, my name is Christine Brown. I'm the Director of Member Engagement here at the Reno Sparks Chamber. It's great to continue to offer these bite-sized educational opportunities to everyone, and honestly, a little bit of a distraction potentially from the craziness of the general election that we are still very much in the throes of. But luckily, we are not here to talk about that today. We're here to talk about some important business guidance that Jim has compiled for us. And of course, Jim Newman of Holland and Hart is one of our valued board members here at the Chamber. We appreciate his engagement and his leadership, not only with the Chamber, but also in our community. And so today we're going to talk about some legal questions that surround a lot of the business decisions that our folks are making, in their day-to-day lives, and especially now in the midst of COVID. And a couple notes on the call. If anyone has any questions, just feel free to pose them in chat at any point during the presentation, and we will address those in the Q&A portion of the call afterward. Also, these calls are always recorded, and we always post them on YouTube after the fact, so people can reference them, and of course, look back and zoom in on any portions of the presentation that they feel are most pertinent. So we're proud to offer that to folks as well. And of course, if you have any questions about what Chamber EDU workshops are coming up, you can always find those on the Chamber website under events and programs. We still have a handful more coming up, including our workshop on mental health in the workspace, which I think is going to be well timed, headed into the holiday season. And of course, right now in Washoe County, unfortunately, COVID cases continue to rise. And so there's a lot of added stress at this particular time in this particular season. So we hope that everyone will take some time out of their busy schedules to join us for that workshop. We think it's going to be incredibly valuable. So with that, we'll just go ahead and get started. And Jim, I will turn it over to you and over to Rachel as well.
Good morning, everyone, and thanks for the introduction, Christine. And Rachel, can you bring up the slide set? So again, thanks for joining, and we're going to spend a little bit of time with you this morning talking about some various legal principles that we think will be of interest to you and your business. Next slide. It's just a couple of bullet points on my background. I'm primarily a corporate and merger and acquisition attorney. And as Christine mentioned, I'm a member of the Reno Sparks Chamber Chamber of Commerce. I'm a board member there as well. For those of you that don't know about Holland and Hart, there is a picture of our footprint throughout the US and some facts on the firm as well. So what we're going to try to do today is understand some main challenges that many companies face from a legal perspective, understand the potential implications of not addressing those challenges, and learning 7 strategies to be able to compete more effectively in the marketplace. So what are some of the challenges that exist out there? One is not having a buy-sell agreement. We'll talk a little bit more about what those are. Another is not protecting your intellectual property. If you're in an acquisition mode or buying another company, not understanding the business that you're acquiring. And if you're selling your business, one of the challenges is if you agree to what is called an earnout as part of the payment. And we'll talk a bit more about that as we move on through the presentation this morning. So what are some of the not so good things that can happen if you don't prepare for those challenges? Well, you might end up, if you don't have a buy-sell agreement, for example, you might end up with partners or owners that you didn't select as part of your business. You might be placing your business at risk, and if you're not protecting your IP, exposing it to expensive litigation. And if you're taking an earnout as part of the consideration for selling your business, you may not be realizing the full value of the company. But the good news is you can not drive off the edge of the road as the last picture depicted, and you can stay on track if you follow the strategies that we're going to be talking about today. So some of the strategies of successful companies, as we have observed, are those that leverage seasoned advisors. They maintain strong funding. They avoid ownership disputes. They protect their intellectual property. They utilize acquisitions to grow. And when they decide to be acquired by somebody else, they exit profitably. In other words, they're strategic about how they conduct their business. The benefits of those 7 points: maximizing your exit value if you do sell a company, keeping control of the company until you decide to have a liquidity event like a sale, reducing the risk of litigation, and protecting your intellectual property. So part of our checklist for being strategic is investing in a usable strategic plan that will guide your growth. Using that strategic plan to guide your decision-making and allocation of resources within your company or business. Ensure everyone reads and lives by it. And if you take the time to do a strategic plan, it's equally important that you update it probably on an annual basis. In terms of leveraging seasoned advisors, we suggest you select advisors who work with your type of company. So depending on what space or business you're in, try to find people who are familiar with that space or business. Select advisors who want to build long-term relationships, and have them tour your office or facility, preferably on their time, to get to know you, your team, and your business so they can assist you more efficiently. In terms of maintaining strong funding, we think it's a good idea to have a strong relationship with your banker so that your banker is someone who knows you. Maintain and grow your operating funds in cash, and supplement as needed with either equity or debt financing. So just in terms of the most basic principles of debt and equity, a lot of people don't understand that debt can be convertible to equity. So sometimes we see that as a method of financing. Debt is also senior to equity. For example, if there's a bankruptcy proceeding. Equity generally falls into 2 buckets, either common or preferred. And as the name suggests, preferred equity or preferred stock, for example, has certain rights and privileges that you don't find in the common equity. We're going to talk for a minute about avoiding disputes among owners or ownership disputes. Having a buy-sell agreement, and they go by other names, but buy-sell is kind of the most generic. Having a buy-sell agreement is very important to avoid ownership disputes. Many people don't understand that unless restricted by contract, equity, such as stock, is personal property and it's freely transferable. That means if you don't restrict transfer by contract, one owner can transfer freely to someone else, and it may not be someone that you want to have as an owner of your business. Buy-sell agreements can also be used to establish the company's value on a periodic basis, and they're part of maintaining ownership records and observing legal separateness. And they can also determine or specify what the buyout details will be if somebody in fact does leave the business. For example, are they going to be paid in cash? Or are they going to be paid with a note? Or perhaps they'll be paid with a combination of the two. All of those things would be spelled out in a buy-sell agreement. So some of the common triggering events, in other words, the things that make buy-sell agreements become operative, include a change in employment status. So if you're an owner and you also work in the business and you decide to leave or change your employment status or consulting status, oftentimes that means when you no longer work for the company, you can no longer be an owner. Dissolution of a marriage can be a triggering event. A person's disability that prevents them from performing the normal functions that they provide to the business. And death can be a triggering event as well. So now we're going to talk a little bit about protecting your intellectual property. Intellectual property consists of things like trademarks, patents. We'll talk about those in a moment. What a lot of people don't understand, there's also in many states, including Nevada, statutory protection for things that are called trade secrets. Those can include things like your customer or your vendor list. Intellectual property can create barriers to entry to your industry. They can also result in increased valuation for your business if you go to sell it. These are the most common types of intellectual property: patents, copyrights, trademarks. Service marks are just really a trademark for a service as opposed to a business that makes products. And then also trade dress. Many people aren't familiar with that phrase. The best way to think about that is some of the casinos, for example, in Nevada that have very unique facades or outdoor appearances, that's trade dress, and it's a form of intellectual property as well. So how do you protect that intellectual property and your trade secrets? Does the company own rights to its intellectual property and trade secrets, either outright or through license agreements? If it's outright, it means you own it. If it's being licensed to you, it's like leasing a car. Somebody else is renting the intellectual property to you for your use pursuant to certain guidelines. If some of the founders of the company invented something, did they assign that to the company as opposed to keeping it in their individual name? And documenting ownership of the intellectual property is one of the primary ways you can protect it. So how do you document IP ownership? There's a number of different ways. It can be done in confidentiality, non-disclosure, and assignment of inventions agreements. These are agreements that oftentimes employees are asked to sign. And by asking the employees to delineate if they have anything that they think they invented, if there's going to be a potential dispute or problem, that's one way to head it off. You can also document it with standalone agreements, or IP ownership can be part of a consulting agreement or part of an employment agreement. So we're going to switch gears here and talk for a moment about acquisitions and some of their benefits. You can use acquisitions to jumpstart growth when organic sales within your business or company are stalling. It allows you to quickly enter new markets. You can acquire new intellectual property, skills, talent, and facilities. and it's a way for you to leverage your existing brands. So it's very important that you conduct careful and thorough due diligence to understand what you're buying if you're in acquisition mode. For example, which key contracts and relationships are critical to retain after the purchase is completed. For example, are there employees that you need to keep or vendors that you need to make sure that you keep on board? And of course, deal structure is important, how you're going to pay for the company that you're acquiring. If you're going to be selling, how do you exit profitably from your business? And when's a good time to sell? What's the condition of the industry and the economy? How well will the company run without you? What's the condition of your company? These are all questions that your acquirer will ask of you. Some of the key considerations: pre-deal stage, no shop covenants, letters of intent, and breakup fees. So it's typical in many instances for there to be a letter of intent that will specify some of the key provisions of what the agreement is. It'll talk about the purchase price, how it's going to be paid, but it may also include a no shop covenant that says for some period of time, you can't talk to other potential buyers or acquirers. You have to talk to the person that you signed the agreement with. And it may also discuss breakup fees. If for some reason the transaction gets signed but doesn't get consummated, there may be breakup fees that parties pay to one another to reimburse each other, largely for some of the professional expenses and other fees and expenses associated with the transaction. Structure is usually discussed. Is it going to be a sale of assets, a sale of equity, or a merger? And what's the consideration? How are you going to be paid? Is it cash? Are you going to be paid in stock of the acquirer? Are you going to be paid with a note or an earnout? Or is it going to be some combination? It could be a combination of any of those four things. And lastly, is your transaction taxable, or is it possible that it could be structured in a way that is tax deferred? You still end up paying the tax, but you pay it later. Other considerations: is the transaction going to be taxed at capital gain or ordinary income rates? Capital gain is usually cheaper or a lower rate. What representations and warranties and disclosures are you going to be asked to make in the transaction documents? This is a big issue for sellers, because if you rep and warrant something or disclose something and it turns out not to be true, and the buyer suffers financial harm as a result, the buyer can seek to recover money from you through a process called indemnification. So the reps and warranties and the indemnification to some extent go together, and they're very important concepts that are usually heavily negotiated in acquisitions. There may be covenants not to compete or solicit. If you're one of the key persons in the business or one of the owners, you may have to sign covenants that say, I will not compete for some period of time, nor will I solicit, for example, employees or vendors. If you're one of those key people, you may be asked to sign an employment or consulting agreement for some period of time after the transaction is closed. So in summary, we've talked about all of these points leading to being strategic in your business. And if there are any questions that you'd like to ask about the topics that we just covered or something else that's on your mind, I'll do my best to answer for you.
All right, Jim, thank you so much. That presentation is so practical and so helpful. I know it jogged my own thinking on a couple of areas that could be good to take a look at. So thank you so much for that. In particular, what I found interesting was, talking about a strategic plan. I think that's a good place to start. And my question for you is, I imagine in your sphere, you've encountered a lot of different strategic plans for businesses. I'm curious to hear which what elements of a strategic plan would you say are signals of health? And what would you say you've seen in strategic plans that are perhaps red flags for businesses?
So a lot of people may be familiar, Christine, with the phrase or the concept of SWOT. So
Mhm.
it's a part of the strategic plan, which is an analysis of basically your strengths and weaknesses. And I think it's important for businesses when they're doing a strategic plan to be candid and honest with themselves. Um, Most businesses have some strengths, but they're probably going to have some weaknesses or some blemishes as well. So I think that's a critical component, and it really goes to whether or not the company and the people writing the plan are being honest with themselves about what the company's prospects are.
Mhm.
Make it very self-serving and only accentuate the positive. But if there's someone that's going to be reading that plan, a banker or somebody else who's involved in your business, they're going to be able to kind of see through those things, I think.
Yeah, certainly. I think if you're surrounding yourself with the right people, you're surrounding yourself with people who are going to ask the right questions and ask the tough questions. So that is important. That transparency, that honesty, that self-awareness is key. Are you willing to talk a little bit about Holland and Hart's strategic plan? As perhaps an example we can look to of a successful strategic plan.
Well, a lot of people, especially when I give this presentation, ask if the law firm has a strategic plan, and the answer is it does. I've been with Holland and Hart since 2008. It's an iterative annual process. There are a number of lawyers at different levels of the firm, partners and associates and others that participate in that planning process. And it's something that seems like it's always going on. You kind of update the plan, and it seems like it's just been out there for a short period of time, and then you start seeing emails. Well, we're going to start talking about modifying or updating the plan. So I think that's an area where this law firm has kind of put its money where its mouth is, and it's something that is an ongoing thing that I think has been something that I'm aware of happening. I haven't personally participated in it, but it's something that's going on really all the time.
Right. I think that's key. And I think that could not be more relevant right now, not only to have a strategic plan, but also to make sure that it's nimble. If there's anything that's true, it's that what we knew about our businesses 8 months ago is not the same today. And so it's that the strategic plan is not something that should ever gather dust. It should be in front of us constantly. We should be evaluating, tracking progress constantly. So those are very wise words indeed. I want to talk a little bit about intellectual property, and I think I have a personal curiosity about this because in my former life as a journalist, a manager in a newsroom here in Reno, that was an issue that came up often, in particular in the realm of social media. We know, especially now amid COVID, so many businesses are engaging digitally more than they ever have. And there are a lot of sticky situations businesses can get themselves into when it comes to social media, when it comes to using perhaps photographs that you may or may not have ownership of or rights to, or even audio media or visual media of any kind. I'm curious, if you perhaps have any pointers for businesses who are active on social media, and what it may look like to make sure that things are shored up in their digital operations when it comes to intellectual property.
It's a great question, Christine. And I think, social media has some overlaps into intellectual property, but as social media has become more and more prevalent in the United States and other countries, it's really kind of an area of the law unto itself. So people who are experts in social media would probably say, oh, I'm not an intellectual property lawyer. I'm a, whatever they call themselves. There's certainly some relationship between the two, but I think you raised some good points. A lot of people don't understand that, for example, in Nevada and most other states, you have certain privacy rights that are defined by statute. So to take a photograph of somebody and then use that photograph without their permission. That can be a violation of the law. And everyone, I think, is now more and more familiar with, things like Yelp and people giving reviews. And we have clients sometimes that feel that they have been unfairly, or their business has been unfairly characterized in a certain way. And they're very, very difficult decisions for business people to make. Really can be troublesome because, some people think, well, if you just leave those things out there, a few people will read them, and then, the news will go away. It's not a big deal.
Right.
Other people feel like you've got to get right on top of those things, or else they're going to, kind of become a real problem. And with the speed at which social media moves these days, you may find out about some bad post about your business 2 or 3 or days or weeks after it's happened. And then the question is, well, how do you sort of erase or undo something that's already taken place? So I think those types of things present real challenges. And also businesses have to be very careful about what they post on social media, because there are laws about defamation. And if you say something that's not true and it's damages a business, that's actually, if it's defamation in the context of a business, that's what we call per se defamation. It's happened, and now it's just a question of what damages does that person have to pay to restore the reputation of the injured person. So it's a very, very complicated area in and of itself. And there are people in our firm and others that really specialize in those areas. It's a little bit different than intellectual property, but there is some overlap.
That is fascinating. We could probably do another call just on the intersection of social media and the law and how it affects businesses. That could be a call for another time. So staying with intellectual property, you mentioned that businesses can license their intellectual property, and I can imagine that this actually in this unique time in which people are looking for new revenue sources. People are looking for ways to perhaps leverage their brand as a way to expand and grow their business. This could be an option they would want to look into. Can you describe some scenarios in which a business might want to look at licensing their intellectual property and how that would come about?
Sure. So intellectual property is very expensive to develop and maintain. And among the types of lawyers that do intellectual property work, people that prosecute patents, trademarks, things of that nature, they tend to be more trained than a lot of their colleagues, because oftentimes they have technical backgrounds or scientific backgrounds. It's not uncommon to find somebody, for example, that does patent work for pharmaceuticals that has a PhD in some hard science. Well, with all that training and expertise, those people are very expensive to hire and have work for you. So from a timing perspective and from a resource allocation perspective, let's say that there's some technology out there that your company thinks it can exploit or make use of, but you're looking at how long it's going to take to develop that independently so that you're not infringing on an existing patent holder, for example. And you start to add up the dollars that it's going to cost to develop that technology. It may be that there's another company already out there that has that technology. They've already patented it. And it can be far less time consuming and far less expensive in some instances to just go to that company and say, hey, can we license your patent, or can we license your other technology? A license agreement basically says that you get to use that technology, usually in exchange for what's called a royalty, which is a fee that's paid to the owner. And there will be guidelines about the use. You may have to market differently than that company does, or you may have to use a different name. They will have guidelines as to how you package and describe the product and things of that nature. But essentially what you're doing is you're renting or leasing that technology from someone who already has it. Somebody else has already spent the time to develop it, perfect it, get it patented, and they've already spent the money to do that. So that's the primary situation. If you want speed to market and to be able to get to market with that product at a lower cost and not have the concern of, is what I'm developing going to be infringing upon somebody else's intellectual property? So there are just all kinds of good reasons why licensing is something that makes sense to explore if that's something that's part of your business.
Absolutely. I could not agree more. And I think right now is the time to evaluate those kinds of revenue streams, and it's a very wise piece of guidance. I just a quick before I try to start to wrap things up, perhaps with one or two more questions, since we're closing in on the end of the half hour. I want to invite anyone who's on the call to ask whatever question they may want to ask that may be coming to their mind. Nothing is really off the table, I would say, in a lot of regards, since we have a smaller group. Even if it's a question that's a little bit more granular in nature, while still, of course, being along the subject lines we're talking about. Now is your time, so please take that opportunity if you want to, if you can. But as a final question from me, I'm curious if someone is looking to perhaps sell their company, but they have some pending litigation. There's a lawsuit going on. What does that look like in terms of their ability to make that sale? Does any kind of pending litigation prevent the sale of a company, or would you not recommend someone make an attempt to sell their company while there is pending litigation going on?
So the short answer is almost all companies have litigation at some point in time. If you've been in business for a long time and you've avoided it, then you've been lucky, and congratulations for not having to go down that road. But there are lots of things that a potential acquirer looks at in determining whether or not they're interested in acquiring a company or a business. Obviously, if you've got massive litigation, if it's patent litigation or it's employment-based litigation over perhaps you've been misclassifying your employees for purposes of overtime or things of that nature, those types of things can be very, very expensive and costly. But what I have found over a number of years in doing this is the most important thing is to make full disclosure. So the due diligence process, just tell the acquirer, well, we've got this lawsuit going on. It's patent litigation. It started 2 years ago. We think we're going to prevail on this, but never know. And the acquirer can look at the court documents, or you can provide other information to them, and they can make their own assessment as to whether or not, how much does that litigation concern them. And they may have a specific indemnification. We talked about that earlier. They may just say, look, we're going to ask you to hold aside, let's say you're selling the company for $40 million. They may say, we want to specifically put aside at closing $3 million because we want to see what the outcome of this litigation is. In other words, they don't want to give you all the consideration at one time. They may say, we're going to put some of that into an escrow until we wait and see how this litigation turns out. But there are other things that can be troublesome, and also there will be things that they find very positive about your business. So I've been doing this for 25 years. I've never seen a particular piece of litigation or some other problematic aspect or characteristic of a business completely kill a deal. It just leads to negotiation. And as we said, there may be some specific contractual obligations to deal with that.
Sure. All right. Well, I think we're closing in on the end of our time. Oh, we're over time, actually. My apologies. Thanks, everyone, for hanging in there. And thank you for joining us today, those of you who are able to make it. I want to thank you, Jim, for joining us today, for sharing your expertise. Thank you, Rachel, for clicking through those slides for us. That was incredibly helpful. And Jim, I'll toss it to you to see if you have any final thoughts really quickly before we sign off.
No, if anybody has any follow-up questions or things occur to them, later in the week or next week, you can find me at the Holland and Hart website, and I'd be happy to talk to you further.
Awesome. Well, thank you very much.
I'm sorry. What is the website? I apologize.
Oh, you're fine.
hollandhart.com.
All right, hollandhart.com. Perfect. And so we'll be able to find your contact info, Jim, after that point, which is incredibly helpful. Oh, thank you, Rachel, for popping that into chat for us. And once
Thank
again,
you.
Jim, you have my gratitude. Thank you, Kurt, for your question. That was a great question. And with that, we will go ahead and sign off, everyone. Thank you so much.
Thank you.